CyberKongz goes knives out, Coinbase gets a W, and AI agents know what you're having for breakfast tomorrow. All that and more coming up on Block and Order. Welcome to Block and Order, the show that explores the legal issues facing the world of Web3 and beyond. I'm Kyle Lawrence, and with me, as always, a man so smart he can solve a Rubik's Cube while juggling chainsaws, Moish Peltz.
If I could do either one of those, Kyle, I'd be really impressed, but I don't think I can.
I had assumed that you would have been able to do one of those. You probably can juggle chainsaws. It's not that hard.
I probably could juggle chainsaws. I would just need to practice.
Just go to Home Depot and practice. I'm pretty sure that nobody would arrest you or kick you out of the store. I cannot juggle at all, nor can I solve a Rubik's Cube, although I guess I've never tried. I don't know.
You've never tried to solve a Rubik's Cube?
I don't think I have.
You handed one at some point.
It's like a parlor trick at a party or something, but not. You know, I can clap with one hand in a weird way.
Tried to crack it. Okay.
No, I never have. So maybe next episode that'll be. We'll just sit here and watch me do it, either for 30 seconds or for 3 days, depending on how long.
Slow meditative state of just solving a Rubik's Cube over the course of dozens of hours.
Exactly. Well, Moish, I think we're going to try something a little different on today's episode. Normally, we do our typical point-counterpoint with the topics du jour, but I think we're going to start with the CyberKongz Wells response, if I'm not mistaken.
That's right, Kyle. We're going to try something a little bit different today, and that is we are going to take a look at a Wells response submission from counsel for CyberKongz in response to a Wells notice received by the SEC. So if it's okay with you, I think we're going to take some time. We're going to run through this document. We're going to basically read it for our audience and give some thoughts as to what we think. Because I think this is a pretty interesting document. What do you think, Kyle?
To be honest, I knew they responded, but I have not dived deep into what their response was. So this will be kind of a learning on the fly moment for me, and I'm here for it. I'm ready.
All right. Well, this is exciting. So, first of all, this is from January 7th, 2025. We're recording today about a week later, January 14th, 2025. It's from counsel. And as you can see, it's saying to the enforcement staff of the SEC, who issued a Wells notice to CyberKongz LLC, that Wells notice alleged violations of Section 5 of the Securities Act against CyberKongz relating to the Genesis NFTs and bananas, which the staff uses in investment contracts under Howey, and under Section 15 of the Securities Act, and against, there's redacted is the original founder, it appears, of CyberKongz, arising from his receipt of Web3 creator fees. So, Kyle, you see in this section here, the proposed action would allege violations of Section 5 of the Securities Act of 1933 relating to the Genesis NFTs and banana tokens, which the staff use as investment contracts under Howey, and Section 15A of the Securities Exchange Act of 1934 against the redacted artist arising from his receipt of Web3 creator fees. So what's the distinguishment between here, Section 5 of the 33 Act, and Section 15A of the 34 Act?
It's interesting. I'd be curious again to see what the actual Wells notice is, or to see what information the SEC has in sending out this Wells notice. Section 5 of the Securities Act of 1933 is basically the requirement that anybody who sells a security register it with the SEC, a security being an investment contract. We've talked about Howey on the past on the show, and I'm assuming we're going to get into it a little bit more as we scroll down. But essentially, if you sell something to an investor, it either has to be registered with the SEC or it has to be filed pursuant to one of the exemptions from registration with the SEC, which is a lot of the work that I do. So you sell something, has to be registered or has to be exempt. Section 15 of the Exchange Act relates to broker-dealer rules. So basically, if you're somebody who trades securities for somebody else or takes in money and raises capital for somebody else, and you get paid as compensation for rendering that service, you need to be a registered broker dealer. You need to be registered with FINRA. You need to be registered with the SEC. There's a lot of different and very complicated rules depending on what you are, what you're doing, what state you're in, how much money it is, et cetera, et cetera. I'd be curious to see how that even comes into play here, because that would mean that, one, there is a securities offering, and two, somebody profited or received the compensation on the basis of like raising capital in connection with it. That seems awfully tenuous. We'll scroll down and see what it gets into here, but that seems kind of strange.
Yeah, I mean, I think that has to relate to CyberKongz and the artist, failing to register under Section 5 for the issuance of the NFTs and the banana tokens, and then as against the artist, for his receipt of Web3 creator fees, like I guess saying he's a broker for receiving like NFT creator fees. So, I guess we'll see how that works out for you as SEC.
Yeah.
And so we don't have the benefit of the actual Wells notice. As far as I know, that's not a public document.
That's correct.
So we are, to be fair to the SEC, we're relying now on, one side of the story. So we'll see what they end up, if anything comes from this and they end up bringing anything. So the other note of, just as part of the introduction here, it seems clear that the SEC staff used the offer and sale of securities, both the Genesis NFTs and the banana token, to have occurred on October 17th, 2021, which is the date that the Genesis NFT smart contract was upgraded. So it's from an initial OpenSea smart contract where the creator had basically put up the NFTs, the 1,000 original Genesis NFTs, to a new smart contract that included the banana token as a future. And so even though we don't have the SEC's original Wells notice, we do know from the summary, at least the summary treats it as the SEC is mad about the upgrade and deployment of the new Genesis NFT smart contract, which included the banana token. And you can't get around it. We're talking about banana token. It's kind of funny, but this is crypto.
It is pretty funny.
So in here, here's the, kind of overview of CyberKongz. Is a 1,000 collection NFT, 34 by 34 pixel gorillas. Were among the first to popularize NFT mechanics such as tokenomics for its utility token, banana, breeding a baby gorilla NFTs, of the X collection of 3D avatars, designed for metaverse and gaming, and community utility, etc.
Interesting to note that CyberKongz, I didn't know this, they're registered in St. Kitts and Nevis, a small country down in the Caribbean, which honestly makes sense. We've seen all of these companies register in the Cayman Islands or Marshall Islands or wherever it may be, just outside of the United States jurisdiction. So no shocker there. And they still got dinged. So just word to the wise out there, just because you set your company up outside the United States does not absolve you of liability if the SEC comes after you.
Well, so that's exactly it, right? Everyone's like, oh, we're going to set up this company offshore and spend all this money because then the SEC can't come get us, right? But
it doesn't work that way. And when I would tell that to clients or prospective clients, and they would look at me like I'm crazy. So no, I'm not. Thank you.
And even here, look, right, the artist, even though we don't know his name, he's from Europe. So European artist, St. Kitts and Nevis LLC, Wells notice. Here we are. Now, obviously, the SEC would still have to establish jurisdiction and so forth in the context of litigation. So they still need to find a way to haul them into court. But that's the sum and substance of this Wells response is not, there's no jurisdiction over us. But who knows? Maybe there's other discussion. So it looks like,
I'm not sure.
This is interesting too, right? The initial sale back in March 2021, the guy fell asleep, woke up to learn that all 989 or so on sale had sold, earning about $15,000.
Oh shit!
Of which he donated the bulk of the proceeds to 2 charities. So the guy made $15,000.
Yeah, it's so quaint. Right.
Donating most of it to charity. Okay. And at the time, did not exist as a project, had no website, no community, no employees, Twitter account was open just a day or two before the art went up in overseas.
This is incredible.
And Discord channel was open the last day of the sale. So there's no marketing for the sale. Man,
So,
2021 NFT vibes. Like, I love it.
I know, it's incredible. Hard to believe that they launched at that point. For some reason, I thought they existed earlier than that, but I guess that's when the real NFT bull run was.
Well, so what?
Interesting.
Bored Apes
Yeah.
was like a month later, I think early April. So,
Oh, really? I don't think I
yeah.
realized that. Yeah, I thought it was okay.
So
Yeah.
this is right in the heyday because I
Yeah.
think the one big thing that had happened before that was the NBA Top Shot launch, which I think was
Right.
back in fall of 2020 was when it became
Right.
popularized. And so then it was like early 2021 when people started realizing, oh, you can make lots of money flipping NFTs. And that kind of led this like cascade of new
Yeah.
NFT sales.
Interesting. Wow. A real
Yeah.
history lesson here today.
Yeah, we need a time. I have a timeline somewhere. We could pull it up. Maybe we should start, Charlie Day with the map of different like.
What the hell are you talking about? This company is being bled like a stuffed pig, Mac, and I got a paper trail to prove it. Check this out.
The bird law. Yeah.
Yeah. Well, bird law is a different thing, but okay.
I know.
All right. So then we're getting into, interest arising for CyberKongz after the NFT sale and the idea of the banana token coming from the community itself. So, of course, it went viral. Community participants began advocating for the building of a larger ecosystem. Banana, which is a concept, did not exist until after the March 21 sales were completed, began circulating as an idea for the ecosystem.
Oh, and it's
from the
user.
idea.
Yeah. Sorry.
No, I mean, feel free. I'm not trying to monopolize the screen here.
It's interesting that it's user generated and a user based idea, which to me, if we're looking at it from a pure investment contract standpoint, I just don't understand how the SEC or any agency can claim that it's an investment contract when it came from the users themselves. And that just seems to fly in the face of what these protections are meant to cover. I don't know. That just seems so counterintuitive to me.
Well, that's the whole thing of, if you look at the DAO report, which is the 2017 guidance from the SEC, some of the only guidance we actually have, the original DAO was very much like an ICO of, we're going to sell this and then it might, like, things might happen, we might make money and everyone's going to share in that, which was very much I think a top-down securities law analysis. But I think this community, like when I think DAO now, I think very much of this community of, there's this thing that we all center around, but it's very much community driven. And yeah, there might be people that are more or less spearheading the community, but essentially the community is going to make suggestions. They're going to take a temperature check. And then whatever the community consensus is what's going to kind of rise out of that. Right. And that's what you're seeing here is community idea of gorillas, bananas, breeding, eating bananas to get baby NFTs, using the banana to customize your NFTs, writing a customized biography for it based on the banana token, community gaming, providing banana all at once for breeding. So otherwise you can breed all 4,000 baby NFTs in a single day. So there's daily yield. So 10 bananas per day for 10 years for Genesis NFTs arose from this idea. And then the CyberKongz NFTs could be collectibles that could be traded, have different attributes. People claim all the banana in one day. Because
just to reiterate, the SEC has held collectibles are not securities. Sorry, I had to get that in there.
Well, so that's why they're emphasizing in this Wells response these concepts, right? Community driven, the collectible nature of the activity, gamified ecosystem, slow drip of collectible NFTs for free that keeps the community enthusiastic and engaged. This all sounds like, trying to frame this as not a securities transaction, but as a communal art thing.
It's the Aaron Sorkin defense. You remember that show Newsroom, which, forget about politics. The reason I didn't like that show is because that entire show was Aaron Sorkin framing a specific argument in a way that only he could win. And then he proceeded to win the argument. And that's kind of what they're doing here. I'm happy to agree with them, but that's what they're doing.
Yeah. I mean, well, that's any legal brief, you're advocating for your position, right? So that's the idea here. So again, if we had the SEC side of it, we can compare them side by side.
Right.
But we don't have that.
We don't.
I wish we did. I wish we did have kind of a fully fleshed out record that we could do that, right? But that's not how this goes.
We invited Gary Gensler to appear on our show. He has an open forum to discuss this and any other matters he would like. Commissioner Gensler, the mic is yours, sir.
5 more days.
Got a couple more days.
So, here's some more detail on the evolution of the banana token, published on a Medium article, having immediate utility because owners of 2 Genesis NFTs could use banana to breed a baby gorilla NFT using the banana as an input. And you did not have to update your smart contract, your NFT onto the new contract if you didn't want to, but you could. So April 17th, so this is about a month after the NFT sale. Man, things used to move so quick. Now it takes years for anything cool to happen.
Exactly.
The Genesis NFT was upgraded, introducing new features. Here we go. And it's including, this gaming NFT ecosystem and a play and collect adventure run game for CyberKongz NFTs and minting experience. So all this thing is happening. Again, no one paid to receive banana.
Yeah. There's no infusion of capital. There is no investment of money. There is no investment contract.
So here's what they say, Kyle. As there was no investment of money.
Hey, look at that.
There was no pooling of funds, no horizontal commonality, and because no money was invested, there could be no expectation of profit derived from an investment. So, Kyle, what does no horizontal commonality mean?
To be honest, I'm not sure how they mean it in this particular context. But what the concept that they're getting at is, we all know what a Howey Test is. For better or for worse, it's an investment of money in a common enterprise with an expectation of profit derived from others. If I had to guess, they're talking about the second prong, the common enterprise, in terms of horizontal commonality. There is no common enterprise here. It's each person can basically play the hand they were dealt. They can do what they want with their NFTs. They can do what they want with their banana token. It's not, I'm putting in money and I'm going to sit back and the makers of this game are going to make some money and then share it with all of us. That's not what's happening here. There is no investment of money. There is clearly no common enterprise, and any profits that are going to be derived are really derived ostensibly from your efforts, not the efforts of the founders. I agree with you in that we have to take this somewhat with a grain of salt because we're only hearing CyberKong's position on this. But assuming that these facts are true and we have nothing else to gauge it against, I just don't understand the SEC's position here, other than it's just their last salvo before they all leave. It doesn't make sense to me.
Well, to play devil's advocate, there is an LLC here. They didn't mention, by the way, when the LLC was formed and the, kind of the efforts that went into the centralized vehicle behind this whole enterprise. But presumably there was some, at least minimal activity to do that. And there was some development of the smart contract, which was deployed, which then launched a token, right? So Kyle, what about that? Isn't that kind of a common enterprise?
Arguably it could be, yes. But I would think in order for there to be a common enterprise, it's kind of, we're all in this kind of together and we're all playing by the same rules in terms of profitability. A simpler example is your typical real estate fund. You and I go in and we chip in money and one of our partners launches a fund and we just kind of sit back, but we all share in the profits equally or pro rata based on how much money we put in. But if it's, we both put in the same amount of money, and you're kind of playing it differently and you're going to get a different return and I'm playing it differently and I'm going to get something completely different, then there's no common enterprise there. Just it's not. We're kind of all doing our own thing, and any profit that we derive is really from our own efforts, not from somebody else. That's just a specious argument for the SEC to make there.
Okay. Well, I'm sure that's where they're going.
Right. Probably.
Right. The common enterprise is this entity that's creating the smart contracts and selling things to people, right? Even if that's not really what happened.
Well, it's that. I mean, here I see the heading right here. Secondary trading of banana. It's the SEC presumably is taking the position that you started this thing and people got rich off it. And you never registered with us. You come in and register, and you didn't do that, so now you're being punished.
Well, I mean, look, the two footnotes here, footnote 4 and 5, I think are pretty interesting. One, footnote 4 says it's the staff contention that April 2021, the date of the upgrade of the smart contract, is the date of securities offering. So I think that's really interesting. I don't know if we've seen other cases where the mere upgrade of a smart contract is the milestone by which security is now being offered, as opposed to the initial deployment of something, or like an ICO, or a token generation event kind of thing, which I guess this kind of was, because it did go from a pure NFT OpenSea smart contract to a more decentralized token enabled smart contract, like fungible token enabled for the bananas. And then footnote 5, it's our understanding that the creation of a secondary market for banana by community members is the basis for staff's concern that the banana yield, together with the availability of a secondary market trading for banana, and jumping to the end of the footnote, makes banana an investment contract. Under Howey, as discussed, the 3 prongs required to establish an investment contract are not present. So, I'll go back up to the heading that you're reading, but community members created banana liquidity pools on platforms like Uniswap and SushiSwap, enabling banana to be exchanged. So they're saying anyone can create a liquidity pool, which is essentially true.
But that's not CyberKongz doing it. That's the members of their ecosystem. How is that CyberKongz fault?
Right. So CyberKongz never sold banana, neither directly or on liquidity pool or secondary marketplace. Never made any money from the sale of banana. Neither CyberKongz nor Mr. Redacted got compensated when others sold banana. And to the contrary, they've provided banana for free at giveaways relating to gaming ecosystem or organized airdrops.
I should read down before I start talking.
No, okay, we'll finish the just the council was formed in July, and other kind of people dedicated to building the expansive gaming ecosystem. All right, so again, let's play a little devil's advocate here, which is CyberKongz did not sell the banana.
Mm-hmm.
They did not create the liquidity pools, but they did deploy the smart contract, the upgraded smart contract, knowing that banana would be kind of sprouting out of it, and that people would receive that banana, and that would be, they would be able to realize a profit from that banana. Isn't that, Kyle, this pernicious economic reality that we're so wary of?
Well, it's certainly the economic, great word. It's certainly something that the SEC talks about when they can't fit their square peg into a round hole. But I mean, how far back do you have to go in order to claim, that CyberKongz is responsible? George Washington formed our whole system of government. Let's blame him for everything that's wrong in the world today. I don't mean to be flippant about it, but seriously, it's like the more you read about this stuff, CyberKongz really had not nothing, but they didn't have anything to do with the specific things that the SEC is alleging. These specific things and the profits derived from them violated the securities offering. But it was the users who did it. Just because you set up the platform, this is the Silk Road thing all over again. In a way, it's you created the platform and people exploited it. I'm sorry, I can't get there.
Well, I'm going to agree to disagree with you on the comparison to Silk Road here, because of the factual assertions that came out in the conviction. But I'll save that for another day. I didn't wear it. I have my free Ross on day one shirt, and it's worth a plug that day one is in like 6 days. So we'll see if Ross is in fact freed between now and our next recording.
We will see.
I wonder if that's one of those things that will be forgotten in the first few days. We'll find out. All right. So now we're getting into, so that was all, pages 1 through 5 were all, factual background, statement of facts, right? So now we're jumping down into the argument section. And so here's what they said. There's all the facts. That's the facts as CyberKongz sees them, at least. And given all those facts, there's no cause of action under Section 5 of the Securities Act of 1933, as the Genesis NFT is not an investment contract under Howey. So here's the restatement of the Howey Test: investment of money, common enterprise, profit solely derived of the efforts of the promoter. Facts and circumstance analysis, where you look at the economic reality and totality of the circumstances to determine whether a contract exists. So, I mean, here you go, in terms of applying the facts that we'd already previously reviewed to the Howey law, discussed in the facts section. When the artist, sold his NFTs, he was surprised they were sold.
That's funny.
There were no sales in April 2021 when the staff asserts the security sale occurred, but rather a smart contract upgrade that included the banana utility token. So the NFT sales happened in March, and then there was an upgrade of which no banana tokens were ever sold. Now, Kyle, tell me why CyberKongz should get the benefit of, I mean, this is something I've seen in other NFT contexts, which is there's an NFT sale. The NFT sale happens at one point in time. There's some period of time, there's a delay, then there's an airdrop of fungible tokens from, by virtue of the non-fungible token. So there is a sale of the NFT, and then there's no sale of the token, but there is kind of this attenuated connection between the sale of the NFT and then the receipt of the fungible tokens.
Right. We would have to see what the SEC's position is. Again, we haven't seen their actual Wells notice, and they certainly haven't filed an action that enumerates what the claims and their version of the facts are. Historically and typically, when you have a securities or an investment contract, the SEC views the sale date as the date in which the issuer receives the money from the thing they sold. So if I sell you something and you give me $1 million, but I don't give you the token or the equity or whatever it is until a month later, it's still the date I get the money that they treat the sale as having taken effect. So again, there's just a lot of we don't know here in terms of what the SEC's position is. And again, we're taking CyberKongz at their word for what happened.
Right. And then under their telling, right, I mean, to counter my own discussion, there was no concept of, it's not like they said, hey, if you buy this NFT, you're going to get banana token in a month or two. Just like, give us some time, which I think would be much more clearly
correct.
Like, give me the money, I will give you a profitable return.
Much different analysis, right? If that was the case. You are correct.
But this telling is, give me the money, you get some art. Sometime later, like, yeah, it's like the SpongeBob SquarePants, like, and like a little bit later, kind of, put the slide here if we can do it. Oh, by the way, the community wants to help build a banana token because it's funny and we can start breeding our NFTs. Okay, so then this is kind of their argument here, right? The proximity of the actual sales, which occurred when persons visited OpenSea and bought the Genesis NFT in March 2021, becomes clear that the staff is pushing the sale date back 1 month, understanding that his sales of NFTs, which are art, in March 2021 are not an investment contract under Howey. And they're doing that to rewrite history and argue the sales occurred later than they actually did, by the staff asserting that something purportedly of value, the old smart contract, was provided in exchange for a new smart contract containing the banana utility token. But closer review makes clear that there was no payment of money, no one received any benefit for the upgrade, and nothing of value was received by CyberKongz.
Yeah, again, taking them at their word, it just you fail the Howey test, and if you fail the Howey test, that's kind of it. You have to satisfy each prong in order for there to be an investment contract.
Yeah, I mean, it's interesting because they're saying each owner of the Genesis NFT received the same NFT on the smart contract. So it's not as if it's an upgrade, but they're not really getting anything different, at least for the NFT itself.
Another question
does
I
not
have.
Envision investment contract as contemplated, as we were saying. No one paid any funds, no capital raise occurred, no pooling of assets, no promise of security would increase in value. Regardless of these facts, the positions that the smart contract upgrade is an investment of money under Howey. it does seem like a kind of a crazy, like when framed this way, kind of crazy proposition.
And what I don't understand, and maybe they get into this later on in their response, but the SEC's mission, the reason they exist is to protect investors from nefarious ne'er-do-wells in the space. There are a lot of them, people who mislead investors or who put out false information, pump and dumps, rug pulls. I mean, we see it every day, especially with meme coins that we may talk about a little bit later. But here, I don't understand who was harmed, unless I'm missing something that they cover later. It doesn't seem like everybody was a willing participant. They knew what they were getting into. CyberKongz has been a very successful project. A lot of people have made a lot of money doing these things. And it doesn't seem like CyberKongz did anything to run afoul of even the tenuous laws that they're trying to ascribe to this industry. I just don't get it. And I don't mean to be a shill for crypto, and I don't mean to say that the SEC is never right. There are plenty of times where they get these things right. But on this one, I just don't get it. I'm sorry. I can't see it.
I can't really add to that. We're so far beyond the concept of investor protection that I don't even know what to say.
And that's the end of that chapter.
All right. So, moving on through the argument, there's no investment of money to upgrade the Genesis NFT smart contract. This is the same thing. Like, I love this argument. The technological update, like downloading an update to your Apple iPhone, in no way resembles an investment of money. So upgrading your smart contract, if you analogize it to, like, if it's a securities offering for Apple to say, hey, you're going from iOS 15 to iOS 16, I think we're actually on 17 to 18, like that would be crazy. You just wouldn't see it that way. Smart contracts themselves have zero intrinsic value and do not trade. Like, yeah, of course.
That's right. Yeah, you're right.
Right. So, okay. I'm curious.
I can't add anything to that. They're right. It's true. It makes no sense.
So, yeah, I'm like, okay, that doesn't make sense. So now we're getting into some, additional detail on what a smart contract is and how an upgrade's performed. I think I'll skip this for now unless you have any.
Here is another discussion of Howey
for the smart contract upgrade. Nothing was received by those who facilitated the update. Unlike even in Bitcoin or Ethereum, which are, or in other cases pursued by the commission.
At no point, see, I didn't own a CyberKongz, and I just don't see anything in here about how they, you were talking about it before. They didn't do any tweeting about, earn banana token and buy the Lambo. Like that, they didn't do any of those things. So I just don't get what we're talking. I don't mean to repeat myself and harp on the same thing, but
to be fair, this is CyberKongz telling of it. So if there were like rocket ship emoji tweets, like they certainly would not be highlighting them in their Wells response, right?
But I feel like if there was, there would have been an enforcement action 3 years ago, not a Wells notice today.
Touche. Okay, so again, no one paid anything for the upgrade. The staff's argument that the investment of money is a substitution of the old smart contract for an updated one is problematic as it renders meaningless Howey, where a smart contract update will now equal an investment of money. Such construction of Howey has no limiting principle. Indeed, if a smart contract update is an investment of money, anything related to the transfer or update of technology could be an investment of money. And any regulation of smart contracts also regulates the blockchain industry.
I don't even know what to say, Moish. If again, we're taking CyberKongz at their word. If the SEC is trying to claim that the upgrade of a smart contract is an investment of money, you're right. I mean, you mentioned the Apple phone, or the upgrade of your iOS system on your phone. Now everybody has committed securities fraud, or half the country has committed securities. Half the planet has committed securities fraud.
Every software developer has.
What are we doing?
Fraud. Yeah.
What are we doing?
Well, so
guys?
here you're seeing in footnote 9 a citation to Judge Torres in the Ripple case and his evaluation of whether compensating employees and developers for their labor by payment of XRP was an investment of money. And Judge Torres concluded that those distributions of XRP did not satisfy Howey because they were compensation They didn't pay money or tangible definable consideration to Ripple. To the contrary, Ripple paid XRP to them.
Yeah.
So here, same idea. Those electing for the Genesis NFT smart contract upgrade received 300 million tokens. They didn't invest any money. They received tokens. So there's no. I think that's great.
Yeah. And just to be clear, there have been situations where the SEC has ruled that even if you receive something for free, there can arguably be an investment contract. We won't get into how that would work here, but in this particular instance, I don't see it.
Yeah, so this is, I think, one of my favorite parts of the brief. Again, they're analogizing the upgrade of a smart contract as akin to updating iOS on your phone, not an investment of money, and that SEC regulation by enforcement is going to hamper technological development, including simple upgrades to blockchain projects such as fixing bugs, adding features, improving performance. Because if you treat a smart contract upgrade as an indicia of securities transactions, then basically, as this is what you're saying, every company that does any smart contract upgrade has to think before they commit that upgrade, is this a securities transaction? And it's not a tenable rule. And I mean, I don't think that also seems just now very clearly getting into the realm of every time you think about publishing code, which I think is free speech, because your code is speech, writing, and it's all the same thing. So every time you want to speak, just publish code, not even deploy code, but publish it. Like, you have to think, is this a possible SEC violation? That just it boggles the mind.
This reads to me like they are appealing to the incoming commissioner. Paul Atkins is stepping in, and I've seen this a couple of times now in the response, hindering development, stopping the United States, stopping blockchain industry from developing and growing and evolving the way it's supposed to. I mean, that's right out of what Paul Atkins is going to agree with. We all know, and it almost seems like they're kind of, I don't want to use the word pandering. It has a wrong connotation, but that seems like kind of what they're doing here, and rightfully so. I would do the same thing. That's smart. They should do that.
No, I mean, I agree. I agree. So, I mean, this is part 2 of the brief, which 15A of the Exchange Act, where the redacted artist did not engage in broker-dealer activity. So the staff has proposed charging the Mr. Redacted with a violation of Section 15 of the Exchange Act for acting as an unregistered broker-dealer. Based on him as an artist creating the Genesis NFTs and receiving a 2.5% creator fee when an owner of the Genesis NFT sells it to a new buyer on a marketplace like OpenSea. So the transaction, which the artist has zero involvement in, except that he earns creator fees as creator of the artwork. So creator fees, which may or may not be collected by the marketplace, that's right, a lot of creator fees are optional. Our revenues an artist earns when his artwork is transferred to an owner, by an owner to a new buyer, and they're a fundamental innovation of Web3. The staff seeing this as transaction-based compensation, that is, that there's some sort of facilitating a securities transaction, commission, and so the creator's fees are akin to like a securities commission, which is a violation.
It's a little different than what we talked about at the top of this topic when I was going over what Section 15 is. Section 15 of the Exchange Act is. We don't have the benefit of the Wells notice or any opinion or any information from the SEC. But what they're talking about here is, and the rule is correct. I'm not saying what the Mr. Redacted done was wrong, but if you raise capital and you take a percentage of that capital as a fee and you're not FINRA licensed or licensed with the SEC, that is a problem. And that is advice I have given to no fewer than 2,000 people in my career, because they all try to do it. Everyone tries to do it. And I say, you're not FINRA licensed. You can't do it. Well, how are they going to find out? It's like, that's not, it's like, what if I kill someone? What if they don't find out? No, you don't come to a lawyer with that. What if they don't find out? I tell you what the laws are. I'm not the writer of said laws. I think it's just preposterous for them to even claim that. Well, but it hinges on their assertion or their belief that these are securities transactions to begin with. If they're not, then there's no broker-dealer violation, so it's moot. This just gets more and more silly the more you read it. Not the
Yeah, I
response,
mean,
just the
this is
position.
like,
Yeah.
I hope we're just kind of, maybe this is just so slanted that the SEC's argument's
Yeah.
not coming through, but the SEC staff viewing transaction-based compensation as the hallmark of broker-dealer activity based on the passive receipt of NFT creator fees. I mean, I guess we can't be super surprised because I think this does call back to the Stoner Cats and impact theory, which, those were not litigated, but, the agreed orders that were the result of those did include in them the concept of those NFT creators did something wrong by virtue of them receiving the creators
Yeah.
fees. Here we're obviously seeing them pushing back on that notion, and as we're reviewing it, it's like, well, yeah, they're receiving creator fees. They're not brokering securities transactions. That just seems obvious.
It's insane. Yeah. What a reach. That is just a reach, if ever there was one.
And so here, this is the topic we were talking about before was, well, let's look at the economic reality here. There is kind of a overarching entity, whether it's the CyberKongz LLC, and here you're seeing the Council of Kongs, which promotes the CyberKongz brand, answers questions relating to this purchase of NFTs. I mean, they are, in a sense, elevating the value of the NFTs and doing so in some concerted way, but then tying that to the establishment of a Section 15 claim that they're somehow brokering securities transactions. I'm not sure I see the link.
I don't see the link. And again, I don't, I mean, if these people were doing this, then I feel like any C-suite executive at a public company is guilty of this. Because they get bonuses. They get bonuses based on revenues and based on this and based on that, but they're not being hauled into an SEC tribunal, in front of one of those ALJs. This just doesn't make any sense to me at all.
Right. They're inducing, like 15A under the SEC's theory, as explained by this argument, induces or attempts to induce the purchase or sale of any security, and irregularity of participation in securities transactions at key points in the chain of distribution. Like that, I think that would describe almost anything in the digital asset space. It's like I'm advising a client to
Right.
to do or not take some action that's somehow inducement of purchasing or sale of a security.
What if we as a law firm, I mean, a lot of law firms do this, where if you have a client who's raising capital and they come to you and say, we're going to do a private placement memorandum and you're going to help us with it. And we say, okay, it's going to cost $30,000. You pay us half now and you pay us the other half when you finish the raise. And if you don't finish the raise, we waive the rest of the fee. Did we just commit a broker-dealer violation? According to the SEC, yes. And that's insane.
So now we're getting into the factors of whether someone's an unregistered broker. I'm going to skip through, a lot of this, but it's, are they an issuer? Were they involved in negotiations between the issuer and the investor? Do they make valuations? Do they make solicitations or recommendations? And obviously the brief here is answering no to all these factors. Do they negotiate price? Do they recommend the investment? Did they analyze the financial needs of the issuer?
Yeah.
Did they, possess customer funds or securities? Did they advertise for investor clients? Right. So reviewing all the different factors that all the different leading cases highlight, they're obviously saying, and it's just completely unlike any of these cases.
Yeah. Again, I don't understand the timing of this. I don't understand why they would take such a tenuous position on a high profile issue, unless they have some smoking gun that we don't know about. And there's obviously some external factors in play here, because there's something that's just not adding up to me. I don't think the people who work at the SEC are stupid, and I know you don't either, and they're not. These are obviously smart people who understand these laws better than most people. But I don't get this. there has to be something missing here, Moish. There has to be something. I mean, obviously, CyberKongz isn't going to be like, yeah, we screwed up this one thing. They're not going to do that, given the timing of the new administration coming in. But I don't know. There's definitely a missing piece here.
Well, look, I think when it was first kind of publicized that the SEC was, had issued a Wells notice to CyberKongz, everyone's like, wait, what?
It was last month, yeah.
Yeah, so that was back in December. But now that again, we're only seeing one side of the story, and although I will say there have been other SEC actions and crypto enforcement actions where we've reviewed the SEC allegations, we've reviewed the response, and us, the public, have said, "Ooh, that doesn't look good," but then judges have said, "No, this is basically garbage. Like, get out of my court." So, like, I don't want to say, like, just because we haven't seen the other side, like, there's no way this whole thing is not, like, it could just be like, oh, the SEC's like kind of gone to crazy town here, but giving them the benefit of the doubt, let's wait until we see actual allegations from them, or maybe they'll just drop it after this. Who knows? So again, right, just to sum up the argument here, there's only two of these factors that are even applicable. One is that the issuer is CyberKongz, and two, that the redacted artist received compensation in the form of commissions as opposed to a salary. I think that's just based on, as money came in, he got some percentage of that. So that's what I assume they're referencing here. But then that's completely untethered from all the other people buying and selling the NFTs, all the other people volunteering their time to build the CyberKongz gaming development. And so, the redacted artist is not in the securities business, was not employed by anyone who sold security, did not receive compensation for affecting securities transactions. He did not even sell securities in the secondary market. And the creator fee was based on the creation of the NFT art, not to the sale of securities. So for the reasons the commission so declined to proceed. I mean, I just didn't. I think they were a little bit more sensitive to the first cause of action. The 15A cause of action seems
that way. Well, this one's a little more clean. It's cut and dried. It seems. Again, assuming that everything is true that we're reading here.
Yeah, and then there's just a nice little list of additional considerations here, including that each NFT is unique. Yeah. So NFTs are non-fungible. They're not fungible. It's like each one's collectible and its own thing. Now this will be seen in other the dissents we've spoken about previously from the SEC commissioners, Peirce and Ueda from Stoner Cats and Impact Theory and other dissents that, physical collectibles like Star Wars, baseball cards, Beanie Babies have not been enforced by the SEC. Artwork like Beeple's auction has not been enforced against. They're actually quoting here the dissenting opinion where the application of securities laws makes little sense, discourages content creators from exploring and financing artists, writers, musicians, filmmakers, others. The SEC should decline to regulate art markets, and NFTs are digital art protected by First Amendment. So this all calls back to, even, prior guests of the show, Jonathan Mann and Professor Fry, basically suing the FCC saying, art is not a security.
Right.
So this ties directly into that. So here we see even a little further, right? NFTs have not been the subject of interpretive guidance by the SEC, nor congressional legislation. And the new Congress formed in January 2025 has identified cryptocurrency legislation as top priority. So I think that's saying, well, if you're going to enforce, at least wait till.
Right. Right.
But I think it's a good point, right? So the interpretive guidance we've received.
Absolutely.
Is really about, to the extent we have any interpretive guidance, and we'll talk a little bit later in the show about the Third Circuit's opinion on the SEC's guidance or lack thereof. I don't think any of it's been on NFTs.
None that I've seen. That's right.
Aside from
we've only seen enforcement actions.
Actions, right?
Right. That's it. I see.
There's, Commissioner Peirce saying, lay out the law, and then if they violate it, you can bring enforcement actions, but don't use enforcement actions to tell people what the law is, because they stuck the word Bored Ape in there somewhere.
You had to get it in somewhere. They found a way.
Aggressive regulation by SEC enforcement actions against NFTs and other cutting-edge Web3 technologies endangers America's lead in cutting-edge crypto and blockchain technologies, Web3 social networks, and the creation of the next generation of unicorns. I think this kind of gets back to your point about, giving some bait for your audience.
Yeah.
And here you go, Kyle, right? I'll let you kind of work on this last one.
Yeah. Paul Atkins, his quote, if the SEC were more accommodating and would deal straightforwardly with these various crypto firms, I think it would be a lot better for crypto companies to work directly in the U.S. instead of going overseas. There you have it. And I feel like they took that quote to heart in crafting this response. And I don't disagree with their position. Again, I know we said it 1,000 times, but we're taking their side of the facts as gospel, but we have nothing else to go on. As we have for the past several years in dealing with the SEC, we don't have anything to go on from the SEC other than you're a security, enforcement action. It's like Plinko. It's ridiculous.
Yeah, I mean, I think this is, one, a really encouraging quote from the incoming SEC chair, Paul Atkins. I think this is kind of the whole idea here is you and I are U.S. attorneys. You and I work with a lot of really creative, entrepreneurial, bright founders based in the U.S. They have really amazing ideas. They want to do them here. They want to employ people here. They want to pay taxes here. They want to, raise capital and make people money too in the right way. But they're not trying to screw investors. They're not trying to do anything. They just want a pathway to do these things.
Yeah. And the people who are doing something wrong and are violating the securities laws, there is still a framework in place to punish those people and stop them. They're not mutually exclusive. You can still punish the bad people and let the good people build an industry and have U.S. jobs and make Made in America mean something. It's not a zero-sum game, guys. It's not hard. I don't get it. Why is this so hard for you?
Well, we've got 6 more days to see if things start changing around here. So
there you go. That's it.
Yeah. So, conclusion, respectfully request the commission decline to file formal charges in the above captioned matter. And there you have it. And we'll credit Scott Anderson and Max Dillendorf for drafting this argument. So that's it.
Well, more SEC fun, Moish, not to be outdone in the ongoing saga of SEC versus Coinbase. The other day, a federal appeals court directed the U.S. Securities and Exchange Commission to provide a more detailed rationale for rejecting Coinbase's request for specific regulatory rules tailored to the crypto asset industry. The court found the SEC's previous response inadequate and lacking substantive reasoning. Coinbase had argued that the lack of clear regulatory guidance from the SEC creates significant challenges for compliance in the crypto sector, basically, we were just talking about. The company highlighted that traditional securities laws are not well suited to the decentralized and unique nature of blockchain-based assets. Moish, we just spent a lot of time talking about CyberKongz. This stems from the case from 2023 that the SEC was suing Coinbase for operating as an unregistered securities exchange. What do you think about this? Is this a bellwether for what's going forward? Is it just a kind of striking down of the SEC before the new administration takes over and saying, guys, you got to give us something to work with? What's your initial thoughts on this case, on this decision?
Yeah, I mean, why not all of the above, and why not also just a continuation of the judicial branch kind of saying, well, SEC, if you're not having a consistent kind of reasonable, viable approach, like, we're going to call you out on it. I think this is really fascinating because the SEC has been saying the laws of the rules of the road are very clear. All you have to do is follow, whatever guidance is out there. And on that basis, we're free to enforce and do all these other things. And people should know that what they're doing is wrong. And then, Coinbase said, well, can you give us a little bit of a hint? And the SEC's answer was just basically, no, we don't need to. We don't want to. We'll get around to it if we feel like it. And now it's interesting that the Third Circuit, which as Coinbase had asked the Third Circuit to basically compel Coinbase to actually create that rulemaking.
Mm-hmm.
And the Third Circuit didn't go that far.
Right.
They merely said, you need to give a better explanation for why you're choosing not to, because your explanation of I don't feel like it is inadequate and arbitrary and capricious, right? So, I mean, like, look, I think that ties directly into what you're saying, though, which is does all of this kind of lead into now the new administration? And here, this was issued yesterday, January 13th. This opinion, we got about a week before the new administration takes over, and Paul Atkins, who we mentioned earlier, is taking over. And so it seems pretty evident that the people that are going to answer the Third Circuit's query here to more fully explain why they have decided not to issue regulation might be people among the new administration.
Right. It's funny when we think about these enforcement actions and the various lawsuits that the SEC has brought against Coinbase and Ripple and some of the other bigger players and smaller players. We always refer to it as a David and Goliath kind of scenario, but Coinbase is hardly a David in this kind of situation. But what's really interesting here is that, one, we have the new administration taking over. It's all eyes on the SEC and what's going to happen under the new regime. But if Coinbase wins this suit, I feel like you're going to see all of these non-fraud related cases just evaporate pretty quickly. It's hard to see them continuing. So, really cool.
Or, hear me out, Kyle, there will be actual guidance and legislation which you can like follow and do things the way you want to and actually make an honest buck.
Hell, you say. We'll see. Looking forward to it. It's a brave new world, folks. Buckle up.
We'll talk to you on the other side.
That's it. I guess this is our last recording under Gensler's watch. So here we go. All right. Well, I think it's lightning round time, my friend.
All right. So the CFPB, which is Elizabeth Warren's Consumer Financial Protection Bureau, proposed new rule requiring U.S. cryptocurrency companies to reimburse customers for funds lost due to hacks or unauthorized transactions. So this would intend to align crypto wallets with traditional banking protections. Now, Kyle, there's one big difference, which is that when your funds are with the bank, this is like a regulated custodian, and presumably they can have rules and track where the money goes. But where it's with a digital wallet, kind of not really a traditional banking institution, should those same rules apply?
Well, there should be some rules on it because, we get a lot of these phone calls from people who have been hacked or, whatever it may be. Just the other day, somebody called me up. They had their funds on Coinbase and now the funds are gone. They can even track it to the bank, but there's really nothing they can do about it. I do think it's good that there would be some mechanism in place to reimburse people. However, there needs to be some rules because what will invariably happen is somebody will give out their seed phrase or they'll respond to that email that they get from Coinbase, staff or whatever. And when their funds get stolen, it can't just be like, well, okay, I should get my money back because I made a mistake. Like there needs to be some rules in place governing it. I don't know where that line gets drawn, but it can't just be for people who F up and get their money back.
It's almost, Kyle, like the regulations should be tailored for the industry which they're regulating.
Oh, he's cooking with gas tonight, folks. All right. Well, next up, something that I greatly appreciate is University of Southern California linebacker recruit, and I'm going to butcher his name. I'm very sorry. Matai Tagoa'i. I don't know, has made history by becoming one of the first college athletes to accept a portion of his name, image, and likeness, NIL, earnings in Bitcoin. Partnering with the global Bitcoin app Strike, this groundbreaking deal reflects a growing trend of athletes embracing cryptocurrency for financial growth and stability. And I love this because I'm not a college sports guy. I'm from Long Island, and we don't care about college sports. But it's a great thing that college athletes now get to somehow monetize themselves while historically the NCAA just made $1 bazillion and treated the players like cattle. That's my soapbox for the night. So I think this is, the NIL stuff is great in general, but to see cryptocurrency enter the fray, I think is fantastic.
Yeah, look, I'm from South Florida and all we have is college sports, like we don't have anything else except for, I guess we have the Miami Heat, but Dolphins are not a real team. Neither are the Marlins. Panthers are cool. But, UF, not South Florida, but, I went there. The NIL thing, people are angry about because it flips on its head the whole idea of like amateur athleticism. But the previous concept was not sustainable. NIL is obviously the future and how things are going to work. And I think this is great. The college kids are going to take their money in Bitcoin, just like the NFL players did. And who was it, Kyle, that took all their NFL salary in Bitcoin, and everyone made fun of them until like 2024, and then all of a sudden he goes, "Ha ha! Look what happened." But we have a few of those now.
Yeah, we do. Who was the first one to do it? Do you know off the top of your head? We could flash it up on the screen. I don't remember who it was. It's on
Russell Okung.
This is content right here. I don't even know who that is. I don't follow the NFL.
Well, we're going to get excoriated by our. So he took half of his $13 million contract in Bitcoin back in 2020, and he's done pretty well, I would think.
That's using your noodle.
All right, on to our next topic. The end of year 2024 report from Chainalysis has been released with some staggering numbers, including that cryptocurrency platforms have experienced a significant increase in hacking incidents, the total losses reaching over $2.2 billion, a 21% rise from 2023. Included in that are North Korean affiliated hackers who are responsible for at least $1.3 billion of those thefts. That's a 100% increase from the previous year and over 61% of the amount tracked. So, Kyle, what do you think about this surge? And does this underscore the escalating challenges in securing digital assets against increasingly sophisticated cyber actors?
What's the refrain that the criminals are always, 2 steps ahead, especially when it comes to tech and cyber theft and all that. So even if you build a better mousetrap, they'll find a way around it before you even have your mousetrap built or one of the things. But obviously we need to safeguard our assets. Obviously we need protocols in place to protect people. But I'm curious if the increase in hacking incidents and the total losses is consistent with the inflows and the new users and the new wallets that have been created and just the inflows with ETFs and just people getting out. I'm curious to see where that line and where that graph is, because maybe this is insignificant relative to the other side of the coin. Maybe, I don't know, just kind of spitballing.
We'll have to have some of our friends from Chainalysis on to answer some of those questions. It's an interesting point. I think it's also partially tied to attribution, that as time goes on, they're able to identify and give attribution to different kinds of transactions where they may not have been able to do that, a year or two ago. So like the numbers also rise. Like if you look back at like 2022 numbers, there's more attribution because you're able to kind of play backwards things happen from there.
Yeah, good point. Well, a Memecoin feel-good story, which I'm happy to share. In December, Siki Chen's plea for donations to fund research for his daughter Mira's rare brain tumor inspired the creation of the Mira Memecoin on Pump.fun. The token's market cap surged to 80 million, which helped raise over 1 million for the cause. Of course, obviously, its value later declined by 80%. It is a Memecoin. Tiger can't change its stripes. But this event highlights the real potential of cryptocurrency communities to mobilize resources for charitable initiatives. And when you have something like what we have going on right now in Los Angeles, and our hearts go out to all the people affected. I have a lot of friends who live in SoCal. I know you do too. We have an office in Southern California. This is what crypto can do, and we need more of these stories. It's great that we can talk about Dog with Hat and the people making billions of dollars, and that's all wonderful. But this is a great use case, and it warms my heart. It does.
Yeah, I mean, you love to see it. I love to see the crypto being used for good, and this is an example of that. Even if an $80 million market cap resulted in about $1 million of liquidity and a later, 80% crash, for a brief moment in time, some charity happened. And yes, I share your sentiments, on our friends and family and colleagues, out in California, and wishing the best to everyone out there. All right. The IRS has finalized its broker rule. So the IRS finalized regulations requiring certain DeFi platforms to collect user information and report transactions similar to traditional financial institutions. These rules are now set to take effect in 2027 and mandate that DeFi brokers gather KYC data to ensure tax compliance. So critics, such as some people on the show, argue that these requirements could undermine the decentralized nature of DeFi and impose significant compliance burdens on developers and platforms who are not in a position to bear those changes. So, Kyle, now that the rule has been finalized and it's set to take effect, although on a delayed basis, what do you think? Is the incoming administration going to have any hope to change some of this?
I would imagine they'll have a thing or two to say about it. I'm of two minds of this because we've seen things get overregulated and it just crushes the intent for why the thing was formed. However, I like that my garbage gets picked up, and I like that roads get built, and I like that I have water that doesn't poison me, and you need to pay for those things. And you do need to have some tax compliance, but there is a line that gets drawn. I know that that's an unpopular opinion. And you can't have people just cheating on their taxes willy-nilly left and right. But there needs to be, some middle ground there, I think.
Right. I mean, again, it would hopefully be compelled by a regulation that's targeted to the industry that it's regulating and not just heavy-handed KYC data for the purpose of gathering that data.
Correct. I agree.
All right. The big news of late is AI tokens. So, Kyle, we've seen issuance of dozens, hundreds, maybe even thousands of AI cryptocurrency tokens. And then one of the ones I was thinking about was AI16Z, which is a humorous take on A16Z, Andreessen Horowitz's fund, AI16Z, and the ELIZA development released a white paper which outlined their plans for an AI cryptocurrency ecosystem, including things like launching a blockchain to enable AI agents to talk to each other and transact on the blockchain. But Kyle, my question for you is, who bears liability when all these AIs are deployed in a decentralized manner and then they just take on a life of their own?
It's interesting. The question I have is, did AI write the white paper? I actually be curious to know about that. It's a great question, and I think it's very murky. I mean, there's the legal concept of responded superior, which is you kind of shield your employees from liability when they mess up. You have an employee who's out in a company car and hits somebody, you protect them. Is that the same kind of thing? If the AI runs amok, are you ultimately responsible for their actions? I guess that depends on how you program it or how much oversight you have over it. It would be wildly irresponsible if, one of these AIs, I'm just forgive me for being, not the most tech savvy person, but it's like if they launch nukes in other countries, you're like, well, I didn't tell it. I just told it to order pizza and trade some tokens. Like, how was I supposed to know? That's not going to fly if something really goes wrong.
Right. And I think as of yet, there's been like funny things and like humorous things and things that have kind of gone off, the rails, but there haven't been any like, oh my God, kind of explode in your face kind of thing. So we're lucky so far. It'll be interesting to see once an AI does, I think cryptocurrency is where AI is going to be like, hey, I've got some money now. Let me do something fun with it.
Yeah.
And when you see that go awry, it's going to be interesting. And I think we're predicting it here that will ultimately happen. It's just a question of not if, but when.
I agree. Well, that wraps it up for the first edition of Block and Order in 2025. Happy New Year, everybody. And I know it's January 14th. I don't care. I'm still saying it. Very special thanks for joining us. Don't forget to like and subscribe to our channel. Follow us on all our socials. Links are down below in the show notes. Remember, this show is meant for information and entertainment purposes only. Nothing that we say is intended to be construed as legal or financial advice. Please hire your own attorney if you're going to take the plunge down the rabbit hole. Neither the discussion of nor the fact that Moish and I may own some of the assets that we discuss on the show is meant in any way to serve as an endorsement of such assets. A very special thank you to producer Sean, who bared with us through a pretty lengthy recording session tonight. So on behalf of Moish Peltz, I'm Kyle Lawrence. Take care, everybody.
See you next time.